All right, let's dive right into this explainer. If you're a law student or gearing up for the bar, you know Title VI of the Family Code, Paternity and Filiation, can be a total headache. But don't worry, we're going to break down these dense legal provisions into simple, memorable concepts so you can walk into your next recitation absolutely crushing it.
But before we get into the crazy mathematical timelines the law loves so much, I want you to ask yourself a provocative question. Is a child always legitimate if born during a marriage? You know the law loves presumptions to protect the family unit, right? Well, as we'll see, it also loves a highly specific exception.
So, we're going to build our filiation status tree across 5 quick sections. We'll cover the roots of filiation, how to impugn legitimacy, proving filiation, comparing legitimate versus illegitimate rights, and finally, the actual magic of legitimation. Let's go.
Section 1. The roots of filiation. This is where it all begins. Under Article 163, we get the baseline. Filiation, which is just that legal relationship between parents and kids, comes from either nature or adoption. Natural filiation then splits into 2 paths, legitimate or illegitimate. Now, the code mentions adoption here, but for this explainer, we are strictly zeroing in on the rigorous rules of natural filiation. Look at the absolute line drawn by a valid marriage here. Article 164 says children conceived or born during a valid marriage are legitimate. But Article 165, it defines an illegitimate child as one conceived and born outside a valid marriage. Did you catch that? Conceived or born versus conceived and born. Literally, that tiny little wording difference is a classic exam trap, so watch out for it. Okay, but what happens when marriages end and begin back-to-back? Enter the mathematical gymnastics of the 300-day rule from Article 168. I want you to just lock the number 300 in your head. It's the absolute core of the presumption timeline when a mother remarries right after her previous marriage ends.
So, let's simplify this math. If a mother remarries within 300 days of her first marriage ending, who is the presumptive father? Well, if the baby is born before 180 days after the second marriage happens, the law points the finger at the first marriage. But if born after 180 days following that second marriage, the presumption completely shifts to the second marriage. All of this, of course, assuming it happens within 300 days of the first marriage ending. Seriously, draw this timeline out in your notes. It's an absolute lifesaver.
Moving on to Section 2, How to Impugn Legitimacy, or as I like to call it, striking the shield. We just saw that legitimacy is a massive legal shield, and the presumption of legitimacy is incredibly tough to break. Just look at Article 167. A child is considered legitimate even if the mother directly declares against it. Or, get this, even if she's officially sentenced as an adulteress. The law fiercely protects the child's status, basically throwing the mother's own statements out the window.
So how do you break it? Here is a great memory aid for your exams. The PBS rule. This outlines the only 3 ways you can take an axe to the tree of legitimacy under Article 166. P stands for physical impossibility, meaning it was physically impossible for the husband to have intercourse during the first 120 days of the 300 days before birth, maybe due to illness or living apart. B is for biological or scientific reasons proving the kid isn't his. And S is for surrogate or artificial insemination where consent was vitiated by mistake, fraud, or violence. Just remember, PBS.
And knowing the grounds isn't enough because you have strict prescriptive periods to take action. Notice how physical distance dictates the time allowed to file under Article 170. The husband gets just 1 year if he lives in the same city or municipality as the birth record. That bumps up to 2 years if he lives anywhere else in the Philippines and 3 years if he's abroad. The clock is relentlessly ticking the second he knows about the birth or its recording. Now, who actually gets to wield this axe? Well, this right belongs almost entirely to the husband. Article 171 dictates it only passes to his heirs under 3 very specific scenarios. 1, the husband died before his 1, 2, or 3-year period expired. 2, he filed the complaint but died before finishing it. Or 3, the child was born after the husband's death. If it's not one of those 3, the heirs have absolutely no standing.
All right, Section 3, Proving Child's Filiation Status.
Once we know what the status should be, how does a child actually prove it in the eyes of the law? Under Article 172, the law really wants a hard paper trail. Your primary proofs are, number 1, the civil register record of birth or a final court judgment, or number 2, an admission of legitimate filiation in a public document, or a private handwritten document signed by the parent. These are your gold standard pieces of evidence. But hey, what if you don't have those primary documents? The law lets you step down to secondary proofs.
Step 1 is the open and continuous possession of legitimate child status. Basically, the parent has publicly and consistently treated the kid as their own. Step 2 is a broad catch-all. Any other means allowed by the rules of court. But remember the strict rule here. You absolutely cannot use secondary proofs unless you first prove that the primary ones don't exist.
Now here's a beautiful legal contrast. While the husband has extremely short timelines to impugn legitimacy, just that 1, 2, or 3 years, Articles 173 and 175 say the child can bring an action to claim legitimacy or illegitimacy during their entire lifetime. The Family Code overwhelmingly favors giving the child the time and opportunity to establish their true legal identity.
Which brings us to Section 4. Legitimate versus illegitimate rights.
This is the core comparison you absolutely have to memorize for succession and family relations. When you contrast them side by side, it's obvious how the law isolates the illegitimate child's legal ties mainly to the mother. A legitimate child gets the surnames of both parents and falls under their joint parental authority. But an illegitimate child, under Article 176, they use the mother's surname and are under her exclusive parental authority. It's a very clear line drawn in the sand.
And you can't forget the math of Article 176 when it comes to successional rights. The legitimate of each illegitimate child is exactly 1/2 of the legitimate child. Just think of it as a 1 to 0.5 ratio. For every full slice of the inheritance pie the legitimate child gets, the illegitimate child gets a half slice. Seriously, burn that 1 to 0.5 ratio into your brain.
And finally, Section 5, the magic of legitimation.
Let's look at the bridge between our two categories. How does the law transform an illegitimate status into a fully legitimate one? To pull off this legal magic, these exact steps have to happen under Articles 177 and 178. Step 1. The child is conceived and born outside of wedlock to parents who, at the time of conception, had absolutely zero legal impediment to marry each other. Step 2. A subsequent valid marriage takes place between those very same parents. Check both those boxes and boom, legitimization.
Once that happens, it acts like a legal time machine. The effects under Articles 179 to 181 are huge. Number 1. The child now enjoys the exact same rights as a legitimate child. Number 2. This legitimate status retroacts all the way back to the time of the child's birth. And number 3. Even if the child tragically passed away before the parents got married, this legitimation still benefits the child's descendants.
But of course, even this magic has its limits. Article 182 notes that legitimation can be impugned, but only by those whose rights are prejudiced, like other heirs whose inheritance shares might suddenly shrink, and the law gives them a strict 5-year window to challenge the legitimation from the time their cause of action accrues.
We've covered a ton of crucial ground for your studies today. But as you review these rigid family code timelines for your finals, leave yourself pondering this question. How do these strict 120 and 300-day mathematical timelines hold up in our modern era of rapid, highly accurate DNA testing? Biological realities are increasingly challenging these historical legal presumptions. Something to think about, right? Thanks for joining me on this explainer. Keep those memory aids fresh and absolutely go crush those exams.